Well, hello, everybody. It's David Leis, your proud host of Leaders on the Frontier. And we are talking live today, this Thursday, on September the 4th, 2025, the year of our Lord. And a warm welcome to everybody. And we're so grateful that you can join us. We're going to dive into a lot of the news today and then shift to a brilliant panel of two guests that we have. I think you'll really appreciate this discussion. Thank you very much, Matt. And honestly, we are so grateful for your many comments. And so I wanted to bring up some comments today that we can reflect on. And good afternoon, Dave and friends. Kenzie, thank you very much. But we have a lot of comments from you. BS really appreciate this discussion at focusing on solutions. We urgently need more of this talk. So thank you so much from those audience comments. And we get thousands of them. So they mean a lot to us. We unfortunately can't respond to all of them. But, among myself and our producers and so many others at Frontier, we do definitely look at them and they make a difference. So good afternoon to everybody. So the topic today is going to be about land and who owns the land. Are you confused as I am in many respects? We have a kind of a steady drip of very interesting events going on in this country. You remember last week I had two brilliant lawyers on, Bruce Party and Bruce Harlow, about the whole issue of the Cowichan decision in British Columbia and Richmond, BC, among related discussions that really cast a lot of doubt on the status of property rights. And we're going to dive into that today, but also a number of very interesting, I believe, related events that really create a lot of confusion about who owns the land. So we're going to talk about that because that is critical and foundational, I believe, for our country. Is if we look at good public policy that serves Canadians, what kind of country are we going to continue to build here in this country called Canada? So that's the topic. And so I did want to, just as people come on board with our discussion, I wanted to highlight a couple interesting news items, one of which is to honor certainly one of my favorite actors who just passed away recently, and that was Graham Greene. He certainly has been a very prominent actor. You may remember him from years ago with Dances with Wolves. And it's interesting. He also got the Order of Canada. He died at the age of 73. And it's interesting, in a 2018 interview with Reader's Digest, he said he was asked if he felt it was important for him to tell the stories of First Nations people. And then he said, not particularly. He said, I've played old Jewish men, New York police officers, French soldiers. I'm a fan of diverse casting. I hate that phrase, Graham Greene, native actor. So he said, you don't hear people say Denzel Washington, black actor, or Kevin Costner, white actor. So I thought that was very interesting, his approach to just simply being a brilliant actor. There's a lot going on in the news. You may have heard that our Prime Minister says that first major projects will include different port infrastructure. He was commenting about that, as reported in the Epoch Times, about developing investments in Canadian ports, including the Port of Churchill, and the vision of trying to ship natural gas to different countries, including to parts of Europe. So let's see those projects happen. So, we'll see as Parliament starts up again, or rises, as they say, on September the 15th, just around the corner. It's also interesting in other news that Canada Post just reported its second quarter loss of some $407 million in 2025, marking the largest quarterly loss the struggling Crown Corporation has announced to date. So we all know that we need, what is it called again? Good mail service. So what's the solution? Should that be privatized, quite frankly? Let's get a solution on that. You may have heard also an interesting news in Alberta that the province announced a ban on school library books with sexual content. They want to, I believe the goal is to try to announce appropriate content for books for children. But in response, the Edmonton School Board seems to be playing a bit of a game by banning other books. And I have this clip from the Premier of the province.
That parents were showing us that were accessible to children in elementary school libraries. And so we asked school boards to use their discretion to identify books that might not be age appropriate for elementary school children. And then and Edmonton Public is clearly doing a little vicious compliance over what the direction is. And so if they need us to hold their hand through the process to identify what kind of materials are appropriate for senior high school students, what kind of materials are appropriate for junior high school students, and what kind of materials are appropriate for elementary school students, we will more than happily work with them to work through their list one by one so we can be super clear about what it is we're trying to do. We are trying to take sexually explicit content out of elementary schools that is inappropriate for me to show on the television news at night, and so it is inappropriate for 7-year-olds to see. That's what our objective is.
So what do you think about that issue? Is it appropriate to have arguably what many would define as, well, what is it again? Oh yeah, pornography in the schools. And so we'll see how that unfolds. And good afternoon, Prairie. We're glad you're back as usual, among so many others that are hopping on here. I also wanted to highlight a fascinating story if you're not aware of it. And I did want to mention that I have an interview that's going to be released shortly with an intelligence official namely Scott McGregor. And this story has to do with projects Cobra and Breeza. You may have heard that this was reported in the Bureau. It's a kind of an explosive story, and it basically says that there's been some challenges when it comes to prosecuting people from a massive super lab that was prosecuted somewhere near Kelowna, I believe it is, in Falkland. It's a large quantity of drugs being shipped in concert with Mexican cartels in Canada, with different trucking companies all across the continent. And unfortunately, I believe there were the case on those prosecutions has fallen apart. And so unfortunately, it begs the question: how do we improve the laws to prosecute the bad guys? So keep an eye on that story. And in related news about drug trafficking, you may have seen this clip about a very interesting boat coming out of Venezuela as the U.S. Navy is pursuing drug trafficking from the Maduro regime. And here you see in real time the photograph of the boat being destroyed. And I believe 11 persons were killed on that boat. But it certainly sends a signal, a message, if you will, to the bad guys that no drug trafficking on this scale is going to be tolerated. So what do you think about that? Is that what we need to do to safeguard people's health? Interesting. Robert Kerr says Daniel Smith rocks. I wish we had her in Ontario to get things straightened out once and for all. So that's a round of applause for leadership to deal with those things. And before we dive into the topic at hand around land use, I want to introduce our two brilliant guests because I want to dive into a very, I think, somewhat related topic. And this has to do with home invasions and so-called castle laws. And I want to just set the stage by introducing our two guests. One is a former judge, and he's a brilliant analyst and author. He's a senior fellow with the Frontier Center for Public Policy, and that is Brian Giesbrecht. Welcome, Brian.
Good to be here.
So, Brian, I also want to introduce Tom Flanagan, and you may have heard of Tom Flanagan. He's got a long, illustrious career both in politics. He's a professor emeritus with the University of Calgary School of Public Policy. And Tom is a brilliant author and has written extensively on a whole variety of policy areas, including beyond the Indian Act and related to, probably every key file that goes on in this country. So a warm welcome to you, Tom.
Glad to be here.
So, gentlemen, just before we dive into the topic of land, I wanted to because this is really quite a significant issue of concern, and it has to do with these recent home invasions. They're really quite tragic. where parties are aggressively going into people's homes. We've heard about a number of them, particularly one in Lindsay, where there was the homeowner responded to the intruder, and the intruder had a crossbow, but the bottom line is that they defended themselves and their family. And now that person is being put up on charges. And I think that's well known as a home invasion. And then more recently, there's a case of another party that was defending their family, and he is known as a hero as he tried to defend his family. He's a father of four. He was killed in front of his family in the home tragically, and this was in Vaughan, Ontario. It's quite awful. So there's a lot of calls now, including comment by the Vaughan Chief of Police, and I just want to share that clip with you.
As our police service, we'll follow the laws as they're written. If the laws change, we'll change with the laws. But as it stands, we know the best defense for most people is to comply. As you've just heard, a number of safety recommendations will allow for those that are victimizing members in the community to leave and not harm anyone. It sometimes can fall on deaf ears when members feel like they have to take matters into their own hands. And the only thing I'd say is, if we are going to rely on our community members to take matters into their own hands to solve this problem, we have all failed our community. I've been down at Queen's Park. I've provided comments on bail reform. So have many of my colleagues across the GTA. And here we are again talking about it. And it seems like in some cases, right, we have not moved the needle collectively, because this is not just a police issue. Unfortunately, when it becomes our issue, it's too late. So we need to do something about this issue around bail and about keeping those people off the streets that shouldn't be on the street.
So there's York Regional Chief, Mr. Chief McSween, commenting about the law. And here you have calls for change from the leader of the opposition, Pierre Poilievre.
The law needs to be clear that if someone comes into your house uninvited to steal your property or harm your family, you need to be able to do whatever is necessary to stop them. And my message to the criminal thugs who are invading the homes of Canadians in unprecedented numbers because of Liberal laws is that you should be in serious danger if you go into someone's house illegally and try to harm them. If you don't want to be harmed, then don't invade someone's house and don't threaten their security. The law needs to be very clear that people have the right to defend their homes and their families against lawbreakers.
So there you go. There's calls for changes in the law. And I know that within the self-defense provisions within the criminal code are in section 34 and 35. And so I want to turn to you, Brian Giesbrecht. You're a former judge. What the heck is going on? The last time, I think most Canadians would assume that if somebody invades your home, you can defend yourself. But what's happening here? Help give us perspective.
Yeah, and I'm a rural resident, so it's even perhaps even more urgent for rural people because when somebody invades your property, and I'm thinking back to the Gerald Stanley case where Colton Bushy was killed, if you recall that. It's clear that a person who lives a number of miles away from a police station, many miles away in some cases, isn't just going to be able to pick up the phone and get the police there in a couple of minutes. And people have to have the right and to defend themselves and their families. Poilievre is absolutely right on this. And I don't want to get into the political differences here, but the current government is very wrong when they try to tell people that, no, you can't defend yourself. We see this debate going on in the United States, exactly this debate right now, and about cashless bail and about people being released and people being a threat. People are going to insist on the right to keep their families safe, and the government can't drag its feet on it. It has to make it possible for people to be able to do so.
So turning to you, Tom Flanagan, what's your take on this? What's the bigger perspective? Is the law kind of shifted too far in trying to define what is reasonable force and your right to defend your home?
Well, I think there has to be some sort of reasonable force provision in the law, because you can get people showing up on your doorstep, for all kinds of reasons. Kids ringing the bell, playing games, somebody who's drunk and needs help. I mean, um, things happen, and you don't want you don't want homeowners blowing kids away because they ring the doorbell. So I think there has to be some kind of reasonable force provision. I believe the problem in Canada is not so much the law as the way that judges are applying it.
Mm.
The you know a provision like reasonable force is inherently subjective. There is an element of opinion in there, and if a judge is determined to twist it one way, he can do that. So I'm not sure that. I mean, I'm not opposed to a rewrite of the law, but I think the more fundamental problem is probably with judicial appointments, and that in Canada means electing a different government. Even then, you can't be sure what will happen, but it probably has to start with electing a different government.
Okay, that's very interesting. So, yeah, what do you think about the law? Should there be a reasonable provision in there? Of course, we don't want unnecessary or gratuitous violence as someone steps on your property. At the same time, you want to defend your castle. That's why they're referred to as castle laws, defending your home. And in this case, it's interesting, Tom, that you mentioned about the question about judicial appointments. And is there a problem there? What are your thoughts, Brian Giesbrecht? Oh,
Point,
I
and
think
I
we've got
believe that we at one time. Sorry.
there's just a little bit of a delay on your system.
Oh, I'm sorry. Are you hearing me now?
Now we can hear you.
I see Tom's point, and at one time, not that long ago, we had quite a good mix of, say, conservative and progressive judges in Canada, and I think that has now been skewed, and we have to get back to the point where we have, I believe, a better balance of conservative and progressive judges at all levels of the court.
All right. So there you have it. That's a quick take from, I think, two prominent leaders in public policy, Brian Giesbrecht and Tom Flanagan, on the whole debate about that's emerging really quickly, really under tragic circumstances. And our heart goes out to all the families involved in these situations. But it's very concerning as people want to have safe homes. It's interesting. Justice Warrior says the judges need to be upgraded. I think that's a vote for trying to improve our judges, that somehow common sense would reign. So turning to the topic at hand, the whole issue of land ownership and how do we move this country forward? There's a lot of things that have been happening in this country, and whether it's not just so-called debates about castle laws or defending your home, it's about fundamental questions like property rights. The recent decision in Cowichan on August the 7th, after a record-long trial, if memory serves me correctly, of 513 days, is really quite a clarion call around the question, are property rights clear in this country? And so I want to turn to both our guests and ask them if they have a kind of a brief summation or take on this decision. Does it actually put property rights in jeopardy, or are we just being dramatic instigators here and misstating what the significance of this decision are. Who wants to go first? Tom?
Okay, I'll make a couple of comments. First of all, this is a trial level decision. This will be appealed probably to the Supreme Court of Canada. So we shouldn't get too panicked over particulars of this decision. There could well be some major changes as it goes through appeal. The Supreme Court of Canada laid down the law after there was the trilogy, really, Delgamuukw and then Chilcotlin and now Cowichan. In Chilcotlin, the Supreme Court said that Aboriginal title is a form of ownership, but it's not just a blanket claim to all of Canada by any tribe that wants it. It has to be based on a historical fact of continuous occupancy and exclusive occupancy. I think what's different about the Cowichan case is the judge interpreted these terms very loosely. I mean, this was a fishing village of the Cowichan who would come over from Vancouver Island to fish there in the summer. They didn't have year-round occupancy. It wasn't a habitation. It was a temporary harvesting camp. And they hadn't been there for over 100 years. This was something that they had done prior to Confederation, and then it had lapsed. So it seems to me, from what I've read of this, that the factual base is for the decision is quite weak. The judges have to, at least they shouldn't feel they're at liberty to disregard the Supreme Court. Sometimes they do, but they shouldn't. They have to should work within what the Supreme Court has said in the past. But it appears to me that this judge in this case has gone out to the outer limit of what you could do with that. Now, we talk about all of Canada. Let's remember that situations across the country are quite different. The three prairie provinces in Ontario, or most of Ontario anyway, subject to land surrender treaties, mostly in the 19th century. And so the Aboriginal title was extinguished by those treaties. That was the wording of it. And it was exchanged for occupancy of reserve lands. So this case is peculiar to BC, where there were no treaties, or very few, and perhaps to the Atlantic provinces. This remains to be seen. There are Atlantic treaties going back to the 18th century, but it's unclear to what extent they involved ceding of Aboriginal title to land. The language isn't nearly as explicit in those treaties as it is in the 19th century numbered treaties. So there are possible implications for the Atlantic provinces, but it's unclear at this point. The cases out there are going to have to be tried and so on. Anyway, from what I know of it, and I'm not an expert on the history of this part of BC by any means, but from what I know of this decision, it looked to me like it had was really quite adventurous and is probably going to get revised on appeal. And for the time being, I guess that's where the emphasis should be, is on what happens during appeal.
All right. So thank you, Tom, for that take. What about you, Brian?
Doesn't look like Brian heard.
Well, the last time I appeared on your yes, I did. The last time I appeared on your show, David, I made some statements about the Delgamuukw case being a threat to personal property. Now, you thought being a bit extreme, but now with the Cowichan decision, I think you're agreeing with me. I believe basically that the Cowichan decision, and I agree with Tom that it's a fairly radical extension of the Delgamuukw case, but it's essentially following along with what the Supreme Court decided in 1995 in Delgamuukw, and that is that based on oral histories, you can remove title to property. And I think that decision was wrong. The reason that it didn't raise such an uproar is that it involved land that was far out in the boondocks. This Cowichan decision involves that is in the city, so people are paying attention. The Cowichan decision is definitely a threat to private property, but it's just following along with the Delgamuukw case and the line of cases that followed, which the property, all property. Now, where I differ with Tom is that I don't think it's that clear that in the numbered treaties area, Aboriginal title is not going to be a problem, because the number in the 19th century, what about tribes that inhabited areas in the 18th century or the 17th century? I think title cases, and I think they will be made. I think we're going to see this all across Canada. So I don't want to be alarmist here, but I believe that the Cowichan case is a very serious threat to private property, not just in Fort Richmond, but first in BC and then in other parts of Canada as well.
Mm-hmm.
All right. Well, thank you, Brian, for that summary. I'm talking with two extraordinary policy experts and legal background. I've got former Judge Brian Giesbrecht as well as Tom Flanagan, policy expert, as we talk about whose land is it anyways here in this country and what's the vision going forward. So, Tom, you've given us some perspective here. What's your response to Brian's take on that?
Well, I would agree with Brian that it is possible that the courts will extend the interpretation of this out of BC and into other provinces. We saw this happen with the duty to consult. The original Haida Gwaii decision about duty to consult was based on the fact that there had been no treaties in British Columbia, and that it would be unfair to do things to land while it was still in dispute, so to speak, to do something that might reduce the value of the property without even consulting with the Aboriginal title holders. Well, within a year, that was extended to Alberta, where there were treaties, and Treaty 8 says very clearly that after the treaty's been signed, that the Crown has the right to use the land for other purposes. And nonetheless, the Supreme Court found a duty to consult in the Treaty 8 area in northeastern BC and in Alberta and Saskatchewan, for that matter. So the courts can do strange things with these decisions that you wouldn't expect, and so that's a possibility. Hasn't happened yet, but yeah, who's to say that it might not? On the oral history, I agree with Brian. I think letting in oral history was a mistake. The theoretical reason for that in Delgamuukw was that the court said that the Indians have no other way to make their history known to the court. Their claim to Aboriginal title has to be based on prior occupancy. So how do they prove that? Because they couldn't, they didn't have writing, so they have no written records. But that's a kind of a illiterate line of reasoning, because there are other ways that give you evidence about prior occupancy. You have linguistic evidence. What are the names in different languages of places? You have genetic evidence. There can be genetic markers for specific peoples. Where do you find those markers today? There can be archaeological evidence. Certain kinds of artifacts can be associated with certain peoples. Do you find certain style of pottery, a certain style of basket weaving, and certain styles of weapons? Where do you find them? And then you have the early observations of the first fur traders and missionaries who were on the spot and wrote down what they were hearing from local people and what they were seeing with their own eyes. And you can certainly extrapolate from early observations of people who could write what the situation on the ground was at the time, or maybe not thousands of years in the past, but going back some years prior to that present. So I think it was a bad mistake, because oral history has so many obvious weaknesses. It's not really admissible anywhere else in the legal system, as far as I know. It's called hearsay, and it's not admissible except under certain restricted conditions like expert testimony, which is a kind of hearsay, or can be. But in general, oral tradition would be called hearsay, and it's not admissible. So letting it in is an invitation to manipulation of the historical record. Now, I believe that in the Cowichan case, the judge went back 7 generations in oral history to paint a picture of continuous occupation of the Richmond area by the Cowichan people. Well, 7 generations, that's my grandfather's grandfather's grandfather told me. There's so much chance for corruption in there. That kind of, it's not evidence at all. It's folklore, and it has no business in court. But the judges, in their wisdom, have opened the door to this, and now we're all paying the price for it.
Okay, wow. This is quite a revelation as we basically understand the significance of the Cowichan decision and how this has evolved over the years of decisions by the courts, including Delgament, where the admission of really verbal history is allowed into the court. Really, in my lay estimation, is a violation of rules of evidence. You have rules of evidence to establish credibility and what can be admitted to a decision. So my question, Brian, was this a surprise to you when you heard about the Cowichan decision?
No, it wasn't. I've been ranting about Delgamuc for a long time, and to me, it's just a rather radical extension of Delgamuc, but it basically follows Delgamuc. Just to add to Tom's point, which I agree with completely about oral histories, you can prove to yourself, as a matter of fact, the Cowichan case is proof that oral histories are unreliable. You had 3 tribes, or 3 Indian bands, who each had oral histories in this case. The judge history of the Cowichan people, and deliberately did not accept the oral histories of the Musqueam and the Squamish people. Every oral history, all pre-literate people have oral histories, and in every case, that oral history says what they wanted. It's self-serving. So here we have proof that oral histories are not reliable. The judge said the Musqueam oral history and the Squamish oral history were not reliable. She showed the Cowichan one, but it couldn't. So what I would say is that they are built on a foundation of sand, because you simply cannot take an oral history, somebody else's title. Just as a historical example of a oral history from pre-literate times is a biblical story like Jonah and the whale. Well, some people might take that literally, but that's a contest on something like that. So why would you do that in the case of Indigenous people? There's no difference between the oral histories of any pre-literate people, and sort of endowing oral histories of Indigenous people as being reliable and other people's as not makes no sense. So I think that Supreme Court has to do a major rethink, because right now property rights are definitely in jeopardy, and we need certainty for investment purposes and to have uncertain property rights. It simply can't be done.
All right. So there you have it. There's a overview from both our guests here, from Tom Flanagan and Brian Giesbrecht on this issue. And I guess I can't stress enough the importance of property rights and certainty, as Brian, you just mentioned, certainty for investment to be able to live not only people's lives, but also to be able to enable our economy to move forward. Um, and so I guess my question would be, this decision is being appealed by the BC government, and you can certainly argue that the BC government has enabled this kind of decision in the first place, and that's probably a larger discussion. But to the point of uncertainty, I mean, the fact is that we're even having this discussion today, and there's many, I think, credible analysts that are weighing in saying this does raise problems. There's others that are saying no, this shouldn't be an issue. But regardless, we're discussing this issue, so that leads to uncertainty regarding property rights. And frankly, the other parties impacted by this decision are profound. There's other First Nations that were also making claims. And also you have the city of Richmond. So a number of their projects are now on hold, I believe. And also the Port of Vancouver, I believe, was also a party to this decision. So this is a case study, again, of creating more uncertainty. So it's not just when people, you have home invaders coming into your home that you have some measure of uncertainty. You have uncertainty now when it comes to your own land. So in this case, is there an immediate remedy that needs to be taken, Tom? Like, it wouldn't, like, as we try to move our economy forward, and we know that Canada has been kind of in a decade of stagnation. We've grown by a mere 1% the last per GDP the last decade. How does the government respond to this situation? To me, this would be kind of like there's the graph that shows growth based on GDP per capita in the last 10 years. It's pathetic. We're at the bottom of the list, and our falling standard of living proves it. So in this case, Tom, what would you do in government if you were advising the Prime Minister, as you have in the past?
Mm-hmm. Well, there's relatively little that the federal government can do in a direct way. Behind the scenes, they can tell the government of BC that they want the government to launch a genuine appeal. We should remember that in the Delgamuukw case, the province actually won that case at trial. And the other side appealed, and the province then fired the legal team that had won the original case.
Mm-hmm. Yes.
Brought in new people. Basically, they threw the decision. They abandoned. They had a very powerful decision written by the Chief Justice of the Supreme Court of British Columbia, and they fired their legal team. Essentially, started over. So I think the federal government can try and be sure that there's none of that stuff is going on behind the scenes, but it is legally, it's up to the government of British Columbia to appeal. In the meantime, the federal government can make reassuring noises, but its legal options are limited when you have something before the courts like that. It will depend upon where a potential investment is located. The immediate impact of this case would certainly be greater in areas where there are no treaties, although, as Brian pointed out, it may ultimately extend to treaty areas too. But for the time being, it only involves non-treaties. So its direct impact on, let's say, plans for expanding the port of Churchill would be, not as much. So I think if the federal government takes a vigorous approach, as they say they want to, about expediting projects and getting them go through regulation more quickly, and bringing in First Nations as partners, and so on. I mean, they're saying all the right things. If they actually do these things, then that will help to alleviate concern on the part of investors. But really, it's, the federal options are limited when something like this is before the courts, and it's an area where you can't use the notwithstanding clause. So there's no obvious way for the government to override a a bad decision, or a decision which seems bad from perhaps from my point of view. And also remember, we're talking here about constitutional law. Section 32 of the Constitution Act of 1982, which was very ill-advised in my opinion, but we have it, and that states that treaty and Aboriginal rights are part of the Constitution of Canada. So they can't
And
be.
property rights are not. Is that
No,
correct?
property
Tom?
rights are not mentioned. So, well, the only property rights are Aboriginal property rights. So, if the courts say this is what Aboriginal title means, the federal government has no obvious way of overriding that except through a constitutional amendment. And I'm not even sure what the amending process would be for Section 32. It's not explicit in the Constitution, and then the courts would have to rule on what the amending process would be. So you get into kind of an infinite regress of
Exactly.
So the federal government doesn't have any kind of obvious short-term solutions. I mean, in the long term, they can appoint different judges, and you can change teaching in the law schools gradually, and a lot of things could happen over decades. But in the shorter term, in which an investment decision is going to be made, there's not a lot that the federal government can do except to make reassuring noises.
Well, it sounds like we've backed ourselves into a pickle over many years here, including the 1982 constitutional amendment that was introduced. Again, I can't stress enough that it took out property rights within that 82 act, but put in Aboriginal property rights. So it's really quite remarkable. And I think Bruce Party has spoken compellingly to that dynamic. So I did want to turn now to a very interesting situation, and Brian Giesbrecht has written an interesting article it was featured in the Western Standard. It's been published at Frontier. It's called Land Back at Bloodvein. That land is not stolen or shared, and it's certainly not theirs. And I encourage you to look at that. It was published on September the 1st. And it's a very interesting issue at the Bloodvein First Nation in northeastern Manitoba has decided to ban all non-Indigenous hunters from entering a huge swath of Crown land. They have a number of blockades set up. And your take on this, Brian, is that it's clearly illegal, but the reports are coming in that somehow this is a legitimate act. So help us understand what's going on here in terms of the assertion that, well, this isn't Crown land. This is part of the Bloodvein First Nation.
Brian, I think you need to move to Toronto if you want.
Well,
you get better connectivity. Sorry.
the problem is how these things are being reported, and I point out in that article that CBC referred to Crown land as its land. In other words, the owner being the Bloodvein people. CBC has done typically, instead of saying the Indians have a treaty right to hunt and fish, they refer to this as their land that's belonged to the Indians. So Canadians are confused. Quite frankly, they're confused. The treaties are very, very clear. The Indians had the right to hunt and fish and trap, referred to as traditional land, but they did not own the land, and they do not own the land. And the Bloodvein people are acting illegally. It's clearly illegal for them to blockade the land. Simply don't know the difference between Indian land and Crown land, and it is CBC that is being misinforming Canadians by referring to this as land belonging to the different Indian bands. It does not. It's Crown land. It belongs to all of us, more than I do or any other group, to blockade this land and keep it for their own.
Okay, so Brian, your article is certainly, I would recommend people look at that. It's featured in the Western Standard, but I think you really shine a light on the nature of the treaties and how those parties sign them in good faith. And it was very clear that Crown land is not First Nation land. But it's a very concerning situation because we all need to live together. We need to be able to go through the law, to be able to ensure that licensed hunters are able to go and exercise their license, as well as First Nation communities within those areas. So my question then is, how do we go forward? How do we live together as Canadians, given these kinds of claims that are happening? It seems like we're kind of on a collision course, Tom, and I want to ask, you've written extensively about, well, you've even helped write, co-authored a book called Beyond the Indian Act, Restoring Aboriginal Property Rights. The question is, how do we move forward as a country? It seems like there's a lot of uncertainty. When we look at the Cowichan decision, we've got some First Nations setting up roadblocks. We've got all kinds of land acknowledgements. It seems like everywhere you turn, there's a land acknowledgement somewhere. If we don't kind of know what's up or down in this country, how do we move forward here? What's your insight here, Tom?
Well, I never heard of Bloodvein until today. I don't know where it is exactly, but if it's in Manitoba, it would be in an area that was surrendered by one of the numbered treaties. And so what Brian called Crown land is, it was surrendered to the Crown. Now, by later judicial decision, the courts have ruled that there is a right to be consulted if the land is going to be used for some other purpose, which would interfere with the right to continue hunting and fishing, which is also part of the treaty. So if they want to make an argument that unlimited hunting by non-members of their band is wiping out the game in interfering with their traditional hunting, fishing, and trapping rights, maybe they could try and make that argument. But for them just to declare a unilateral blockade should not be tolerated. And the government of Manitoba, should take steps to do it. Now, maybe some non-Indian hunting guide should go to court and try to get an injunction against this, and then the province could intervene on his side. But that's what ought to happen, is to draw a line on this. This concept of traditional territory, this is not mentioned in any of the treaties. This is a modern concept. You won't find that phrase in any of the treaties. At the time the treaties were signed, there was Crown land and reserve land. Reserve land is a different kind of Crown land. It's land which is held for the use and benefit of the Indians, and then other Crown land is controlled by the Crown for other purposes. This traditional territory thing is not part of the treaties. It's it arose again in the context of British Columbia, where there weren't treaties. So a modern day treaty would take into account the traditional territory where a particular band had lived and hunted and so forth. But it really has no relevance to the numbered treaties, and it shouldn't have ever been let in to the discussion. So the government can't. Now, again, the federal government, what can it do? This is provincial Crown land. It's up to the province to enforce the law within its own boundaries. But this one should not be allowed to stand. And if you have to send in the Mounties, well, then you have to send in the Mounties. But it's a really crucial, important point of law. To admit an ownership claim on so-called traditional territory is just way. Well, really, that's like saying we're going to throw the treaties out the window. You know, we're not going to
Interesting.
live by the treaty. This should not be. Now, I don't know your premier in Manitoba, Mr. Canoe. I'm not sure where his personal sympathies would lie in this case, but I mean, he's got a duty to enforce the uphold the law. So anyway, this takes me by surprise. I had not seen Brian's column, and I'd never heard of Bloodvein, so I'm a little bit taken by surprise on this one. But it is, you know, it's a good illustration of how these things work. You start with a seemingly innocuous principle of the right to be consulted on something that will possibly affect your livelihood. And gradually that gets extended into not just the right to be consulted, but the right to veto. And now it's being extended here into a claim of actual ownership.
Exactly.
You know,
Yeah.
so one salami tactics, one step at a time, you end up in a place that was never really foreseen at the beginning. So on this one, I'm not a big fan of governments taking harsh measures and so on, but on this one, I really think government ought to take a stand. This is quite crucial.
Okay. I think that's a brilliant summation, Tom. This is a very seminal moment in terms of ensuring the law is upheld. Brian, what do you say as a solution here? If you were the advisor to Premier Wab Canoe in Manitoba, what would you recommend?
I'd recommend that he simply, as I say, if a different group of people, if a group of Ukrainian people or what have you had decided to block off an area of Crown land, they would be quickly told that they have no right to do so. Treat Indigenous people like children, and that's basically what our law has done for so long. So I would tell Wab Canoe, just treat them like normal Manitobans and tell them that they have no right to blockade the land, to take the blockade down, and he can meet with them or have his officials meet with them if they have concerns about forbid other people to come on the land. They have no right to do that. That would be my advice to the Premier.
All right. So that's sounds like good advice. So we're getting towards the end of our discussion today, and I apologize for the technical challenges with Brian Giesbrecht's sound. But I did want to wrap things up by saying it's important that we live together in peace and harmony, as they say, as Canadians. And I guess my concern here, Tom, is are we developing kind of two classes of citizens here? Are we developing a path that, from a policy point of view, is simply not sustainable as a nation? If we can't have prosperity together, if there's uncertainty regarding property rights, and I know this, a number of these things are being appealed, but in the meantime, we have uncertainty, and we have, frankly, a lack of what seems to be, and I hope I'm not being unfair, frankly, a lack of political will to enforce the law, to be able to ensure that there's confidence that if there's a violation of the law, that in reasonable fashion it will be enforced. Are we down a dead end path here, Tom?
Well, yeah, quite far, yes, frankly. And there's a lot of different ways that this has happened. One of your listeners mentioned the issue of taxes, and let me say something about that. Indian reserves have been turned into tax havens for members of the band. If they earn income on a reserve, it's not subject to income tax. Now, that's not actually in the Indian Act. There isn't a tax exemption in the Indian Act going back to the 19th century, but it was written to apply to property taxes. There were no income taxes then. The only taxes were property and excise taxes. And the idea was that you didn't want local communities, local governments taxing Indian reserves and then confiscating the land for non-payment of taxes. So that made sense, and I would still defend that as justifiable. But once again, my favorite whipping boy, the Supreme Court, decided that they would extend that to income tax, for which there is no justification. There are poor Indians and there are wealthy Indians. Why should a wealthy Indian living on reserve not pay income tax? So that's just one example of how this kind of passed at the time. There wasn't much discussion. It seemed sort of technical and so on. But we're accumulating so many of these special privileges. And this is one that actually could be rolled back because it's not a constitutional issue. And Parliament could amend the Indian Act to make it clear that the tax exemption applies only to property taxes. But a lot of them are not so easy to roll back. So, the answer to your question is yes, we've done a whole lot of this and we're doing more all the time. Sentencing for criminal convictions is another one. Getting a discount for being of Indigenous ancestry. These things are popping up all over in our life, and in my opinion, the situation is getting worse rather than better. These things do not contribute to reconciliation; they just contribute to a sense of victimhood, and they prompt more demands rather than fewer. So. But it's a huge job. I mean, there are so many of them. We've done so many of these things that, and many of them are constitutionalized and can't easily be retracted, if at all possible.
All right. So this has been a real heart-to-heart about this issue of who owns the land in this country. It's a complicated issue, as you can see, and we have tried to put our best effort to try to bring some perspective on it seems like an accelerating pace by which these issues are coming to the forefront. And it's been happening over a number of years, as both our guests have said. So I want to thank both of you for joining us today, and certainly our audience, Tom Flanagan, as well as Brian Giesbrecht. Very much appreciate you joining us today.
Okay. Bye-bye.
So thank you again,
All right.
Brian
Thank you,
and
David.
Tom.
Nice to
and
see you.
also our audience. Be sure to join us next week at the same time on Thursday. We'll be talking with General Michelle Maisonneuve and Senior Fellow at Frontier about lessons learned about September 11, known commonly as 9/11. And what does that mean for us today in this country as we look to defending our nation? So thank you for joining us today, and have a terrific.
Thank you for watching Leaders on the Frontier. We're a nonpartisan think tank. We explore ideas, policy, and practical solutions that can make a difference in the lives of Canadians. We do not accept any government funding. We work for you. Thank you for supporting Frontier. Visit fcpp.org to give. While you're there, be sure to check out our latest articles and research. Without open discussion and debate, you're not thinking, nor are you free. Comment below. We'd love for you to join the conversation.